A very good morning to all my dear students. Today, we are going to discuss about the jurisdiction and the place of suing. But before recapitulate the points which I have dealt with in my last lecture regarding the I had already apprised you about the doctrine on the basis of which this jurisdiction becomes an important step in instituting a civil suit in a court of law. And that doctrine is UB just EB remedy. Wherever there is a right, there is a remedy. Furthermore, in that, I had also discussed with you about the meaning of jurisdiction, wherein I had defined jurisdiction as the power or the authority of a court to hear and determine a cause, to adjudicate and exercise any judicial power in relation to it. Thereafter, we had also discussed about the relation wherein I had apprised you that it is well settled that consent cannot confer nor take any nor take away jurisdiction of a court if the court has no inherent jurisdiction, neither accusations nor waiver nor estoppel can create it. Wherein I had also discussed with you the case of Kiran Singh versus Chaman Paswa, which is a leading case on this particular aspect. Thereafter, I had also discussed with you the different types of suits to which I have apprised you that the same may be divided into several parts and they may relate to movable properties or immovable properties, or they are based upon contracts or tort, wherein I had discussed with you about I had discussed with you various sections such as section 15 to 20 of the Code of Civil Procedure, which regulates the forum for the institution of a civil suit. Section 15 requires the plaintiff to file a suit in the court of the lowest grade competent to try it. Section 16 to 18 deals with the suits of or suits relating to immovable property. Section 19 applies to suits for compensation for wrong to person or to movable property. Section 20 is a res judicata section and covers all cases not dealt with by section 15 to 19. Thereafter, I had also discussed with you the different types of jurisdiction, that is pecuniary jurisdiction, territorial jurisdiction, and subject matter jurisdiction, in which I had discussed this nature and scope of the same. Thereafter, I had also dealt with the object behind these three types of jurisdiction. And furthermore, In pecuniary jurisdiction, I had also dealt with the modes of valuation, how the same needs to be calculated. As far as the territorial jurisdiction is concerned, I had discussed with you that the same may be the suits may be divided into four categories or four classes. That is with regard to immovable property, movable property, and compensation for wrong or tort and other suits. In with regard to movable property, I had also discussed a doctrine of law which reads as under mobilia sequenter personam, meaning thereby movables follow the person. And this was explained by me as a suit for wrong to movable property may be brought at the option of the plaintiff, either at the place where the wrong is committed or where the defendant resides, carries on business, or personally works for gain. Thereafter, I had discussed with you the concept of other suits as stipulated or contemplated under Section 20. And Section 20 reads as Section 20 provides for all other cases not covered by any of the foregoing rules. All such suits may be tried at the plaintiff's option in any of the following courts. Number one, where the cause of action wholly or partly arise, where the defendant resides or carries on business or personally works for gain, where there are two or more defendants, any of them resides or carries on business or personally works for gain, provided that in such case either the leave of the court is obtained or personally works for gain at that place, accused in such institution. In my last lecture, and today I am going to start with the explanation of section 20 in relation to selection of forum. Selection of forum is based upon the absolutely the jurisdiction of a competent court is void being against the public policy, meaning thereby in selecting the forum, it is necessary that the same can be conferred as per the provisions of the statute, and no agreement can be entered into to take away the jurisdiction of the court. And in case such agreements were prepared or executed between the parties, then the same would be void and against the public policy. But there is an exception to it, and that exception is where there are two or more courts and one of them has been agreed to by the parties for filing a civil suit, then that agreement would be valid in the eye of law. Now, next concept is objections as to jurisdiction. As you all are aware that the court must have the jurisdiction to try a civil suit, and If the court is not having the jurisdiction to try a suit, then it would be a nullity in the eye of law. To this, I would like to point out Section 21 of the CPC, and it is a fundamental right that the decree of the court without jurisdiction is a nullity. What is the object behind carving out or enacting Section 21 of the Code of Civil Procedure? The object behind Section 21 is to protect honest litigants and to avoid harassments to plaintiffs who have bona fide and in good faith initiated proceedings in a court which is later on found to be wanting in jurisdiction. Now, next, what are the objections can be taken as to territorial jurisdiction? Meaning thereby, what are the grounds on the basis of which the objections as to territorial jurisdiction can be taken by a party before a court of law? Number one, it must be taken in the court of first instance, meaning thereby it cannot be taken at the later stages, that is an appeal or revision or before the High Court or the Supreme Court as the case may. Secondly, it must be taken at the earliest possible opportunity. And third, it would only be allowed only in cases where there is failure of justice. If there is no failure of justice, then in that particular circumstance, even though the court would not have the jurisdiction to try the suit, the court may try the same. Next. Objections as to pecuniary jurisdiction grounds. The same must be taken in the court of first instance, like in the case of territorial jurisdiction as well. Second, the same must be taken at the earliest possible opportunity. And last, there must not be any failure of jurisdiction. And if there is any failure of justice by the act, then that decree would be void in the eye of law. Second, objections as to subject matter of jurisdiction. A court cannot adjudicate upon a subject matter which does not fall within its province or defined by law, and if the court does not possess that jurisdiction, a judgment or order given or made or decree passed by it is absolutely null and void. To this, there is a very, very important case which a law student must know, and that case is Hiralal versus Kalinath, EIR 1962, Supreme Court, page number 199, wherein the Supreme Court has held that neither consent nor waiver can confer jurisdiction upon a court, otherwise incompetent to try a suit. Now, the question is whether the jurisdiction concept can be taken or whether the objections with regard to jurisdiction would be taken by a party in respect of execution proceedings or before the executing court or not. Answer is yes. Even though Section 21 CPC did not apply to execution proceeding prior to 1976, but it was made applicable in this case of Hiralal versus Kalinath. So, Section 21 applies also to execution proceeding. Next, what is the bar of suit under Section 21A CPC? It says no objections as to the place of suing can be taken at an appellate stage or revisional stage of proceedings. Further, Section 21A, as inserted by Amendment Act of 1976, provides that no substantive suit can be filed to set aside a decree passed by a court on an objection as to the place of suing. So from this, we may infer that no separate suit can be filed, and the only remedy available to the aggrieved party is to approach the higher courts by way of an appeal or by way of revision or before the same court by way of review. So this is all about today's lecture. Hope you have learned a lot from it. In case you are having any doubt in today's lecture, then you may write a mail to me at my mail ID, that is rahularora.gn@jagannath.org. Before parting with the today's topic, I would like to apprise you about the new topic which I am going to take in my next lecture. In my next lecture, I am going to deal with the chapter on institution of suit, wherein I would like to describe the various steps involved in instituting a civil suit and also discuss the concept of pleadings as well. And the relevant provisions regarding the same are from section 26 to section 35B. Till then, hope you have a good day ahead. Till then, stay home, stay safe, and be positive. Thank you very much. We'll meet you all soon in my next lecture. Thanks once again.